than it is a real demonstration. What is impeachment? When I first came up with this talk a couple of years ago, I tried to come up with a definition of impeachment. I Googled it, I Wikipedia'd it, I checked a variety of law books, legal texts, law dictionaries. There were many and varied and inconsistent definitions. Originally, almost all of the first hits came up with Bill Clinton. But there's been a number of changes since. Now when you Google it, you'll get impeach Bush, impeach Obama, impeach Paraguay's president, impeach Bulgaria's president, and my favorite, why you can't impeach Stephen Harper. But the definition I like most, and the best definition, and the simplest definition, is an attack for reasons relating to prior inconsistent testimony. An attack for reasons relating to prior inconsistent testimony. Impeachment of the witness occurs with very few exceptions in cross-examination. And impeachment, in my opinion, is one of the most important skills a cross-examiner can learn. It is one of the few times when you may actually get a witness to change their testimony. It can be quite dramatic and quite impressive to both your client and perhaps the judge or the jury. Simply put, this is how it works. A witness testifies to a certain set of the facts in examination sheet or in direct examination. But you, as the cross-examiner, know that the witness on a previous occasion has either said or written something that is different or inconsistent with the evidence that they just gave in direct examination. And you want to point out the difference, so you decide to impeach. The previous version may have occurred in a statement the witness gave. It may have occurred in their notes. Most professional witnesses, police officers, doctors, lawyers, investigators make notes. It may have occurred in their testimony in an examination or discovery or in a preliminary hearing. It may have occurred in emails, tweets, letters they wrote. We're only, as Trevor said, teaching one approach to impeachment this year at the ITAW. There's multiple approaches. Lawyers do it differently. There's no necessarily right or wrong way to do it. There's a number of different ways to do it. But I can tell you that the method that I'm about to discuss with you is a simple method. It's a foolproof method which will almost always work. It's a method that I use more often than not. However, at the end of the day, you're going to have to decide which method you want to use. That may depend on what type of case you're doing. It may depend on what form you're doing it in. So keep in mind, this is just one way to do it. The impeachment strategy involves 3 C's. And when you read the material, you'll see that there are 3 C's. These are credit, confirm, and contrast. I will go through each of these in a moment. They're up here in a particular order. You necessarily, again, don't have to follow this order, and you may not confirm depending on what type of impeachment it is. But again, this is the order that I follow. It's a recommended order for a simple, foolproof method of impeachment. So what are the 3 C's? The first one is credit. Crediting the prior statement, crediting the prior notes, crediting the prior evidence. It is crediting the evidence or the information given on a prior occasion. It is not crediting what was said in examination in chief. So it's crediting whether it's the notes of a witness, a report, etc. I'm going to give a brief example of crediting. Assuming it's an examination discovery, Pat, you're up. You attended an examination discovery August the 17th, 2010.
Yes.
You testified under oath.
I did.
You were asked a number of questions about the matter before the court.
Yes, I did.
You gave a number of answers.
I did.
Those answers were given under oath.
Yes, they were.
And those events took place approximately 2 months before today's date.
Yes.
Certainly closer in time to the events than today.
Correct.
And you've never made any corrections to your examination or discovery.
No.
Now, make sure you never, and this is a must, there's no debate, regardless of what method of impeachment you're using, you never say, do you remember attending an examination for discovery? Or do you remember being asked these questions? Why? You don't. It's cross-examination. Tell, don't ask. And if the witness says, no, they don't remember testifying at the examination discovery, or no, they don't remember being asked that question, you're in a very awkward position of trying to prove it. So don't ever, ever, ever say, do you remember when you're crediting or whether you're impeaching. If it was a witness's notes as opposed to an examination for discovery, the matters before the court took place on June 5th, 2010, correct?
Correct.
That was shortly after the events took place.
Yes.
And shortly after the events, you completed your notes.
That's right.
You made the notes when the events were fresh in your memory.
Yes.
In fact, you made the notes before the end of your shift.
Correct.
You received training in making notes.
Yes.
You're trained to make detailed notes.
Yes.
You're trained to make complete notes.
Yes.
You're trained to make accurate notes.
Yes.
And in this case, you did make complete notes.
To the best of my ability.
You did make accurate notes.
Pardon me?
You did make accurate notes.
Yes, I did.
And you know the importance of making accurate notes.
I do.
You know the importance of making complete notes.
I do.
You know the importance of making detailed notes.
Yes.
You know the Crown will prepare their case based on your notes.
That's true.
You know your notes will be disclosed to the defense.
Yes.
You want to be fair to the defense.
Of course.
That's how you credit for the purposes of impeachment. You should credit fully. Do not worry about over-crediting. Why? You can't over-credit. The next C is confirm, and that is confirming or repeating the evidence that the witness gave in direct examination. So you're going to repeat what the witness said in the examination in chief or direct examination. Again, an example, Inspector Beard, in direct examination, you said that Walter Watkins was wearing red pants.
That's right.
The final C is contrast or correct, and that is establishing the difference, pointing out the difference, emphasizing the difference, highlighting the difference, or correcting the evidence. But again, never, ever, ever, and again, regardless of what method of impeachment you choose to employ, never ask the witness to explain the difference. Now, before you impeach, you have to decide whether you're impeaching the credibility of the witness or the evidence. This is a decision you have to make before you get up to impeach, and it will dramatically affect which method you employ. Impeaching the witness's credibility occurs when you don't care about the evidence other than for credibility. In other words, the evidence has no relevance to the outcome of the case dispute or no outcome relevant to the outcome of the case. So this occurs when you have no concern whatsoever about the evidence. You can live with either version. You can live with what he said in examination in chief. You can live with what he said in the statement. All you want to do is attack the witness's credibility, i.e. show that they're unreliable, show that they said something under oath that wasn't true, and it depends on the fact, show that they might be a liar, they might be a poor historian, they might have no regard for the truth. It depends on the facts, but the bottom line is you don't care about the evidence but for the issue of credibility. So I'm going to give you an example. Let's assume, for example, in direct examination, Inspector Beer said that Walter Watkins was wearing blue pants. And in his investigative report, he said he was wearing red pants. For the outcome of the dispute, we couldn't care less what color pants he was wearing. It has nothing to do with the guilt or innocence of Dan Jones, whether he was wearing blue pants or red pants, or he wasn't wearing any pants at all. All we want to point out is that he said in examination in chief it was blue pants, and his report said red pants. So I want to impeach, in this case, the witness's credibility. So here's an example of that. Oops, went too far. So first I'm going to credit. The first C I'm going to credit. What I mean by that, I'm crediting his report. Sir, the matters before the court took place on June 5th, 2010.
Yes.
That was just over 2 years ago.
Yes.
And shortly after the report, you completed your investigative report.
Correct.
You made the report when the events were fresh in your mind.
Yes.
And you made the reports obviously sooner to the events than today's date.
Of course.
You received training in making a report.
I did.
You're trained to make a detailed report.
I was.
You're trained to make a complete report.
Yes.
You're trained to make an accurate report.
Yes.
And in this case, you did make a detailed report.
As always.
You did make an accurate report.
I did.
You did make a complete report.
I did.
And you knew your report would be used at trial.
Yes.
And you made no change to your report since today.
No.
And in your report, you described Mr. Watkins.
Yes.
In fact, you described him in great detail.
Essentially.
And it was important for you to describe Mr. Watkins in great detail.
Yes.
So I credited the report to show how detailed, how accurate, how complete, how thorough, how fulsome it is. You will never get a witness to say he makes bad notes or he makes inaccurate reports. So after I credit, I'm now going to confirm. I'm now going to confirm, repeat what he said in examination in chief. This morning in direct examination, you swore under oath that Mr. Watkins was wearing blue pants.
That's what I said.
Now, after I've confirmed, I'm now going to contrast. Now, you note in your detailed report that Mr. Watkins was wearing a white shirt,
Yes, I did.
because obviously he was wearing a white shirt.
Correct.
And in your detailed report, you note that he was wearing sneakers,
I do.
and obviously he was wearing sneakers.
Yes.
And in your detailed report, you note that he was wearing a tan raincoat,
Yes.
and obviously he was wearing a tan raincoat,
Correct.
because you wouldn't have noted it if he wasn't.
That's right.
And in your detailed report, you note that he was wearing red pants.
I see that. Yeah.
And in fact, he was wearing red pants.
I guess he was.
Now, I'm going to go a little further. But that's not what you told us this morning, is it, sir?
No, sir, it's not.
In fact, this morning you swore under oath he was wearing blue pants.
That's true.
But that wasn't true, was it?
No.
In fact, he was wearing red pants.
Correct.
He was not wearing blue pants.
No, he wasn't.
You were mistaken this morning when you swore under oath he was wearing blue pants.
I guess I was.
When you swore under oath to this jury this morning that he was wearing blue pants, you were wrong.
Yes.
And then you can go further. You can have fun with it. What am I doing? I just pointed out that he was given two different events, versions of the events under oath, and one of them now is not true. So to summarize, when you're impeaching the witness's credibility, as we just did in this example, I went through about he prepared the report, I credited ad nauseum, it was accurate, it was detailed, it was complete, he wrote it out. Credit, credit, credit. Then I confirmed. I went over and got him to repeat what he said in examination in chief. Then I contrasted and pointed out that what he said under oath in examination in chief wasn't true. And again, depending on the case, you may want to go further, you may not want to go further. But the bottom line is, that's up to you how far you go. So just to summarize, when you're impeaching the witness's credibility, when you don't care about the witness's evidence other than for the issue of credibility, the evidence itself, again, is not relevant to the outcome of the dispute. The strategy is you credit, you confirm, and you contrast. There is, again, some debate about the order. This is the order that I personally follow. And again, you'll never get into trouble if you follow this order. Other times, you're going to impeach the evidence. And that is when you care about the evidence. In other words, the evidence or the version given in direct examination hurts your case. The prior statement helps your case. The goal here is to get the witness back to his previous version. I care about the evidence. I need to get him back to the prior version. So let me give you an example of that. So let's assume again in direct examination, he said he could only see Watkins, he saw Watkins from the waist up in the store. But in the investigative report, it's from the shoulders up. This is important to me because if it was only from the shoulders up, he obviously couldn't see the transaction, couldn't see the transfers of the money, the bottle, anything like that. So I care about this evidence. I need to get him back to shoulders up. I can't live with waist up. I need shoulders up. So in this case, you would impeach a little bit differently. You would start out the exact same way, and I won't do it again, with the crediting. You again would credit ad nauseum about how detailed and accurate his report is. You do not confirm. You do not, when you're impeaching the evidence, confirm what he said in examination chief. You do not confirm. You go right to correct or contrast. So I now credit, you made a detailed report, an accurate report, a complete report, blah, 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 blah. Yes?
Yes.
Now, in your detailed and accurate report, you know that you can see Watkins from the shoulders up.
Correct.
You also noted how much of Watkins you could see in the store.
That's right.
And you know that you could only see him from the shoulders up.
That's what I wrote.
And in fact, you could only see Watkins from the shoulders up.
That's right.
Due to the obstructing advertising in the window.
Correct.
Now, I've now got him back to shoulders up. Sorry, correct, to shoulders up. I've won. I've got the witness where I want him. I want him to shoulders up. That's where he is. I may stop right now. I may sit down. In fact, I might be happy if I do. That's it. I've won. If you want to go on and to contrast, you can do so. But even if you contrast, you do not repeat, nor confirm, nor remind the witness of what he said in examination in chief. So I'm not going to, even if I'm going to go to the next step, which you may or may not do, I'm still not going to confirm or go back and remind the witness or remind the trier of fact of what he said in examination chief. So the contrasting when you're impeaching the evidence would be something like this. So after I got him to agree with the shoulders up. So that's not what you said in direct examination.
Correct.
So I'm not repeating it. So in fact, you could not see Watkins from the waist up.
That's right.
So even though I'm contrasting it, I'm not going back to what he said in examination in chief. That is impeaching the evidence. Why you don't go back to what he said in examination in chief doesn't help you. You're not going to mention it in your closing. And I don't want to repeat or sponsor bad evidence. So that's why you don't go back, even you contrast to the examination in chief. So to recap the example, again, repeated all the crediting, went through it, prepared the report, night question, he chose the words, he wrote it, it was complete. I corrected him. Your report says you could see him from the shoulders up. And once you take him to the report, you still have to get him to adopt the report, which was you could only see him from the shoulders up. And if I contrasted, which I did, I still didn't repeat the examination in chief. I just said he couldn't see him from the waist up. So when you're teaching the evidence, use it when you care about the evidence. It's relevant to the outcome of the dispute. You want to get the witness back to the prior statement. So you credit, you correct, you may contrast, but you do not confirm the evidence given in examination in chief. So that is the brief step strategy. When you are impeaching the evidence, sometimes it's not really even an impeachment. Sometimes if you get the witness to agree with the ultimate conclusion, in other words, you can only see him from the shoulders up, you stop. If that's the best, if that's really important to me, I don't want to make the witness look unreliable. I can stop right then and there and live with and be very happy that I got him back to shoulders up. There are different approaches to impeachment. They vary depending on situations. What the facts are and how important it is to you. Some lawyers and litigators will start by